Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Today, we're diving into an exciting recent win for Friedman Vartolo in a rare re-foreclosure case, Prop 213 versus West Fork Funding. And we'll use this victory to explore some of the fundamentals of a New York re-foreclosure. I'm Adam Friedman, managing partner at Friedman Vartolo, and I'm thrilled to be joined again by our senior appellate counsel, Stephen Vargas. For those of you familiar with the industry, Steve needs no introduction. If you Googled New York foreclosure attorney or you went on Wikipedia, Steve's face would pop up. He's that critical and well-known within the industry. Steve, thanks for joining me again. These are always our most popular episodes. How's it going?
Thank you for the very complimentary introduction. It's an interesting topic, one that's seldom discussed, so I'm glad that we get the opportunity to discuss not only the topic in general, but also a good decision for the firm.
Sure, I agree. It's definitely, it's a unique topic, one that isn't discussed very often, so I think this will be great. So before we jump in, what is a re-foreclosure?
Re-foreclosure is an equitable remedy governed by two sections of the Real Property Actions and Proceedings Law, sections 1503 and 1523. Re-foreclosure is used where, through inadvertence and mistake, a necessary party to a foreclosure action is not made a party to the action. The necessary party can include an owner or lien holder. Those are the necessary defendants in a foreclosure action.
So what we're saying is we had a foreclosure, we completed it, and we forgot to name somebody. Correct. So we're going to re-foreclose by basically having a whole other case, right? This is a different action?
Correct. It's a separate action under a separate index number that only is commenced after a foreclosure action is completed. So It's completed against all but, let's say, one party. And in the case we're talking about, that's what occurred here. A foreclosure is brought, it is completed. After the foreclosure action, someone, typically the bidder at the auction, identifies through a subsequent title report that a party was omitted from the foreclosure action. And that's the most common circumstance because that party's interest in the property is not foreclosed or extinguished by the foreclosure it was omitted from. So now the party is left with a situation where they have to take a new legal action to extinguish the interest of the party that was omitted from the foreclosure.
Outside of timing, because obviously this is a whole other action, there's a certain degree of cost and time involved with commencing a new action. Is there any other, I don't want to use the word downside, is there any other negative for the foreclosing plaintiff?
Well, in terms of risk, the statute, specifically RPAPL 1523, provides that in the event the omission occurred through fraud or willful neglect, the omitted party's interest cannot actually be extinguished. So there is a burden on the plaintiff to prove that the omission was not either through fraud or willful neglect. In most instances, it's not, and in the case we're talking about today, it was not. But there is some risk associated with that, because in the event that the omitted party, through litigation, proves there's an issue of fact as to whether it was fraudulently or through willful neglect omitted, there may be a trial on the issue, leading to risk. Ultimately, if the bank can't prove there was no fraud or willful neglect, that party's interest remains unaffected by the foreclosure forever. There's not really a way to cure that. Re-foreclosure would have failed.
Okay, so moving into this case specifically, into the West Fork foreclosure, you want to give us the general facts of the case?
Sure. The plaintiff brought a foreclosure action in Bronx County against what it believed to be all necessary parties, including what, at the time it obtained a title search, was the record owner as well as the lien holder defendants. Prior to commencement, plaintiff obtained a foreclosure title search, like I said, identifying all the parties that would have been, at the time, necessary defendants. Unbeknownst to the plaintiff, after it obtained the title search, but shortly before the commencement of the foreclosure, there was a gap in time, West Fork Funding, a corporate entity, acquired title to the property through a condominium common charge lien auction, so a separate case. It didn't get the deed directly from the borrower. It got the deed from a referee that auctioned the property off at a condominium lien auction. So the bank commenced the foreclosure without getting a continuation search, a gap contin, that's what the industry refers to, that subsequent foreclosure search that the bank would obtain between the initial search and when it commences the action to try to identify any liens that were filed in that or deeds that were filed in that gap period. Bank brought the foreclosure without obtaining that search, proceeded to judgment and sale, bringing the action against the former owner and the lien holders. Auction occurred, the bank won the auction. Subsequently, in REO, the bank identified that West Fork was the record owner of the property and that all the interest had not actually been foreclosed through the auction sale. The foreclosure was void as to West Fork, which necessitated the re-foreclosure action brought solely against West Fork. The bank lien was indisputably superior. The mortgage was indisputably superior to West Fork's title, but nonetheless, the bank had to bring an action for re-foreclosure against West Fork.
There's two parts here I want to just hone in on for a second. The first, you discussed the gap contin or the title bring down. There's a bunch of different names for it, which in New York we're commonly ordering once the lis pendens is recorded, right? I think it'd be beneficial for our audience to explain the importance of that, right? Can you walk us through why something after the lis pendens recording date would not be irrelevant, but it would not necessitate us amending the pleadings?
Of course. Caveat I want to mention first with respect to some counties, including New York City, which is what we're dealing with. Sometimes documents are delivered to the clerk days before the document's actually recorded, which creates a complication, necessitating, like you said, obtaining that additional search to see what's in the land records. In a situation here, even a brief gap, even a short duration between the original search and the commencement of the case, something potentially important like here could have happened. As far as the question you presented with respect to the difference between needing a search to identify liens filed or deeds filed before notice of pendency versus after, in New York and in many other states, the filing of a notice of pendency provides constructive notice to any entity or individual that acquires an interest in a property, whether it's an ownership or a lien interest, after the filing of the notice of pendency. So there is a distinction between a judgment lien or a deed or a mortgage that is recorded in the clerk after the notice of pendency, in which case the party is deemed to have constructive notice, no amendments required, versus a party that files their interest, their lien or mortgage or deed, before the notice of pendency is filed, in which case they are not affected by the notice of pendency. They would need to be addressed by a notice of pendency.
And that's what happened here, right? The West Fork deed was recorded prior to the notice of pendency, and therefore they needed to become a party to the action.
Exactly.
Okay. You also mentioned that West Fork had title, right? And
Yes.
that even though they had title, the mortgage was superior. Obviously,
Correct.
you and I, working in the industry, attorneys, well-versed in these types of proceedings, we understand what that means. But to some people in our audience, to hear that West Fork had title, but they were subject to a mortgage, it could sound a little confusing. Can you just walk us through how someone could have title and still be subject to a mortgage?
So when the borrower took the mortgage out, the borrower's interest pursuant to the mortgage was subject to the mortgage. The mortgage in New York, the mortgage was recorded on whatever date it was recorded in this case, and any interest that's recorded in the county clerk's office after the mortgage is inferior or subordinate and subject to the plaintiff's mortgage interest. New York is a race notice jurisdiction, and there's a race notice statute that specifically provides that. And that's why it's very important to record a mortgage as quickly as possible, not directly related to the issues with the re-foreclosure, but generally speaking, you want to record your mortgage as quickly as possible to avoid the possibility that someone will record a deed, a mortgage, or some sort of judgment lien in the land records or in the county clerk's office before the mortgage, in which case the mortgage could be subject to someone else's interest. So here, West Fork took the deed years after the mortgage was recorded with constructive at a minimum, if not actual knowledge, that there was a mortgage that was recorded many years in advance, and West Fork knew what it was requiring: ownership in a property that was subject to a mortgage, and in this case, in default.
All right, so Steve, moving back to the West Fork case and exactly how we were victorious in this case, right? Everything we've talked about thus far regarding, the deed was subject to the mortgage, that a re-foreclosure is relatively standard when you're trying to bring in a party who was mistakenly not named in the initial foreclosure action. It seems unlikely that these would be litigated. And I know this was a litigated matter. Could you walk us through why this case was litigated? What arguments was the defendant raising?
The defendant relied on RPAPL 1523, the statute that requires the plaintiff to prove that the omission was not done through fraud or willful neglect. So the defendant, among other things, challenged whether the plaintiff fraudulently or through willful neglect omitted the property owner, West Fork, from the action. The plaintiff was able to show that that was untrue, that it just simply did it by mistake, and the omission was purely due to the lack of an updated title search. It proved that it had the initial title search, which showed the borrower, the mortgagor was the owner, short gap in time between when it commenced, from when it got the title search to commencing the case. Unbeknownst to the plaintiff, it did not realize that West Fork obtained the deed, and that was where the omission arose from. Simply a gap in time where it didn't obtain a continuation search.
Are these generally litigated? I know they're not common, but the ones that do occur, are they generally litigated or they're generally uncontested?
I would say 50-50 is a rough estimate. Like you had mentioned, there are very few actual defenses to it. The statute provides the two defenses we discussed. The circumstances are typically pretty similar to what you see here. A lack of an updated title search, a gap in a notice of pendency. If you don't refile a notice of pendency within 3 years from when the prior notice is filed, the first notice expires. If some interest is acquired during that gap and recorded in the county clerk's office during the gap, then that interest would have to be addressed potentially in a re-foreclosure. So it's typically due to some omission of that nature. Just an omission between gaps in notice of pendency or early on in the case, not bringing all defendants into the action at its inception.
Thanks, Steve. To recap, the West Fork funding decision underscores the court's ability to apply equitable remedies in foreclosure matters where procedural oversights occur, ensuring that the interests of mortgage holders are protected, while also giving junior lien holders a fair opportunity to redeem. Thanks for joining Stephen Vargas and I on the Weekly Friedman, your source for the most essential information in the default industry. If you have any questions or comments, please leave those below. Looking forward to seeing you next time, and thanks for tuning in.